Very good evening. Today is our chief guest, Honorable Mr. Justice Manmohan Singh, respected Trivedi Sahib, YG Trivedi Sahib, Jatin Bhai, Mr. Suryadeep Basia, Mr. Bindi Urvi Shah, Mr. Nishant Shekon, Mr. Anubhav Kapoor, Dr. Manish Shah, Mr. Lakshi Joshi, Mr. Sandeep Shah, and moderator Dr. Nidhi Buch. I am really very happy and fortunate to be among you for today's program as a giving a welcome address. And really I feel not only happy but quite obliged to Jatin Bhai and his company. See, today's program's intellectual property refers to the creations of the mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. IP is protected in law, for example, patents, copyright, trademarks, which enable people to earn recognition or a financial benefit from what they invent or create. I'm very happy that YG Trivedi AMA Center for Intellectual Property Rights has been celebrating the IP Summit for almost over 15 years. In these 15 years, many stalwarts have come and shared their experiences and also demand for intellectual property rights in society. We are happy to know that AMA has been catalyst in providing and promoting this opportunity to youngsters and young professionals on intellectual property rights, which is a demanding topic in today's time. We have with us Honorable Justice Mr. Manmohan Singh, is renowned for his tenure at the Delhi High Court. We welcome you, sir. And he was a legal luminary whose impact extended across intellectual property rights, arbitration, and animal welfare. With a career spanning from advocacy to the adjudication, he navigated complex legal landscapes with precision and integrity. His landmark rulings, notably in cases such as Samsung Electronics Company Limited, VK Wadhwa, and People for Animals V versus Mohammad Mohsin and another, reflected his commitment to justice and the protection of rights. Beyond the courtroom, Justice Singh's advocacy for specialized IP benches showcased his forward-thinking approach to legal administration. In essence, his legacy in one of the jurisprudential excellence and unwavering dedication to the cause of justice. So before I handing over the stage to you, sir, I would like to felicitate you on behalf of Ahmedabad Management Association with a memento, and I am sure today's deliberation and panel discussion will give you many better insights and the latest insights for this particular subject. So may I request Gopiben to take charge of the Dr. Hafiz, may I invite you, sir, to give your blessings? Yeah, what, you have a mic also here.
Many thanks to Ahmedabad Management Association for having me here. Many thanks to Dr. Jamin Baswa, Miss Gopi Trivedi, Mr. Satyadeep Basia, Bindi Urvi Shah, Nishant Shukant, Abhinav Kapoor, Dr. Manish Shah, Miss Lakshita Joshi, Mr. Sandeep Singh, Dr. Nidhi Buch. Good evening to everybody. I have been asked to speak on IP. I can see that many sitting here are the expert and professional on IP side. They know better than anybody. But still, basically, I will say something about the subject. I can tell you that if we can say that maximum growth in any system has happened, that is on IP cases. And I will tell you gradually that how it has happened. Actually, 1889, there was no law on IP in India. First time from UK, we brought the act of common law remedy and we started dealing with the IP cases. No injunction were passed. There was no CPC at that time. The interim orders were passed on the basis of specific relief act, like equitable right. If the equitable rights are there, injunction is not granted. If it is a case of counterfeiting or identical trademark, the courts used to pass the order. This understanding continued till 1940. In 1940, first time Trademark Act 1940 came, but there was still dilemma in the minds of the judges, in the minds of the expert, in which cases injunction should be granted, in which cases the injunction should not be granted. Normally, if we see the law from 1940 to 1958, the injunctions were passed only in those matters where the trademarks were almost same, business is same. Like somebody has a trademark Coco Jam. If the defendant is using Coco Jam, then the injunction would be passed. If he is using Coco Lem, the court usually say, no, it is not a case for passing off injunction. The judges were giving the example that the common law remedy will only apply if somebody says he put the basket on their head and he says these goods are coming from Tata. In fact, those goods are not coming from Tata. Only on those type of cases the injunction order will pass. Full-fledged act came in 1958, where basically when the act came, infringement specific action for infringement of trademark at that time was incorporated, section 28 and 29, and common law remedy and passing off was still there as section 27. This was the era where lot of growth, lot of development has happened in India. And I will just tell you few judgments, and you yourself will feel that IP has progressed so much in India particularly. I will tell about the other countries also. First, basically, judgment came after the Act 1960 by the Supreme Court, AIR 1960, page number 142. The trademark was Guluco and Glucovita. The plaintiff lost from all the courts, and ultimately matter went to the Supreme Court, Corn Product versus Shangri-La. There basically the defense was taken, glue is taken from glucose, the number one. Number two, that glucose is very common to the trade, and there are large number of cases where the glucose is prefix and therefore relief should not be granted. And in that case, there was a little different description of goods, that is biscuit and milk. So first time the Supreme Court has passed the order saying that as far as the common to the trade is concerned, if the prefix is added with gluco, so it doesn't matter because we have to compare the mark as a whole. So this finding was given, and in one of the para 21, the Supreme Court has also held that why not basically we should apply the test of different goods. First time they gave the judgment, and ultimately the relief was granted, and in both the counts the Supreme Court passed the order in favor of the plaintiff. The second judgment came in 1969, that is AIR 1969 Bombay, at page number 24, at page number 36, para 49, where basically the Bombay High Court, Justice Chagla's judgment, Bombay High Court says that in para 49, that admittedly there is no confusion, admittedly there is a different description of goods, goods are totally different. That was, the trademark was Caltex, Calcet Petroleum came before the court, and other party was using the trademark Caltex for watches. So in para 49 it was recorded that there is no confusion, there is no question of any mens rea, and therefore dealing with this subject, still we feel that the Caltex should not be allowed to be used by the other party, because ultimately Caltex is the invented word. So this was basically in 1969 Bombay, the landmark judgment was there, which has been cited almost in all the cases where the goods are different, and where the invented trademark in Telerod case also was decided by the Delhi High Court, by the division bench, which was ultimately confirmed by the Supreme Court. They taken the same view like Caltex and Telerod case. This basically, the defendant in many cases taken the defense that no, 69 Bombay will not apply, Caltex will not apply in our cases, because Caltex is the invented word. If there is an invented word, the plaintiff may be having some case. If it is not an invented word, then the court should follow the same law, earlier law. So in another case, the Bombay High Court decided immediately after 1969 in Bata matter. Bata is a very common surname. Somebody, they were using in shoes, somebody was using the Bata for lungis. And Bata basically lost everywhere. And then ultimately matter went to the Supreme Court, and Supreme Court it was compromised, and ultimately the suit was decreed. They said no, there is no justification. In trademark may not be invented word, but still how can you use the trademark? Bata is a very well-known trademark. So even Allahabad High Court subsequently granted the injunction in Bata matter on the basis of the Bata shoes and lungi for form. That was also granted by the Allahabad High Court. And subsequently, a lot of judgments came between 58 to 99, where basically the landmark record has happened in India. One is like Whirlpool case. The injunction was granted up to the Supreme Court. And another case is very landmark, Ellora Industry versus Banarsi Das, 1980 AIR. It's a very interesting case that the one party is using the Ellora Industry, and another party has adopted the trademark Ellora as a corporate name, but main trademark was different. So Justice Khanna, who was at that time district judge, H.R. Khanna, he basically he decreed the suit for infringement, but dismissed the suit for passing off. He said, no, one is using as a trademark, one is using as corporate name. How can basically, I will not grant the injunction. Ultimately, matter went to the High Court, and High Court granted the injunction. And he was restrained from using the trademark LoRa, which is the registered trademark of the plaintiff. And similarly, there are other cases also, because I will not take much time. Mercedes-Benz, that is also very interesting case, that Delmar, the party name is Daimler-Benz versus Hybo Hindustan. That's a very interesting case because it was not recorded in the facts, because I argued before Justice Mahendra Narayan. And the Daimler has got 2 children. Because it's a very interesting, we must understand the logic also. He has got 2 children. The son name was Benz and daughter name was Mercedes. So he was having the vehicles and car all over the world. He was a German citizen. And somebody used, one of the party, Eagle Flash people used Mercedes, and Hybo Hindustan, who were using the trademark VIP, they were using the trademark Benz. So 2 suits were filed before the High Court. Those were listed before Justice Mahendra Narayan. And in those suits, I was the defendant for Hybo Hindustan and Eagle Flash. So there was a delay of 8-9 years. The court was very much in firing mood. They say, how can you use the trademark? One party is using Benz, one party is using Mercedes. It is a very well-known trademark by Justice Mahendra, before Justice Mahendra Narayan. And we tried our best that Benz word has come from benzene, chemical, and therefore injunction should not be granted, and the suits were filed after 7-8 years within the knowledge of the plaintiff why the injunction should not be granted. I say whosoever is practicing on IP side, he must read that judgment. This is reported in AIR 1994. And the court says that there is a dilution principle followed in that case, that you are basically filching the goodwill of the trademark, and irrespective of that, whether there is a confusion, deception, whether goods are same, the car was for at that time 50 lakh, the undergarment was just 5 rupees. So they said no, basically there are certain trademark, why somebody should use it, otherwise the value of the trademark will go. The injunction was granted, and I filed the appeal before the division bench. And division bench, our Chief Justice was laughing. He says, what type of injunction the trial court has passed? One is 50 lakh, one is 5 rupees. So at that time, Mercedes-Benz was not here in India. There was a total ban by Government of India under policy. So there is a question of passing off. And they allowed the appeal and set aside the order of the division bench. The Mercedes-Benz people went to the Supreme Court, and Supreme Court reversed the order of the division bench. They say, no, you basically cannot grab the trademark of some German company, Mercedes-Benz, how can you use it? So this is a very important case on dilution of trademarks. The other judgment is basically, in the meanwhile, Parliament has noticed that there is a lot of development in the country. Globalization was there in order to harmonization of the scheme, because at that time we signed the TRIP agreement also. So why not basically we should repeal the Act of 1958, because there were so many difficulty at that time, because 58 Act says that infringement will only happen when the trademark will be the same, or in respect of which the trademark is registered. So these things, lot of judgment given by the High Court between 58 to 99 were appreciated, not by India, but all over the world, because I have been there in WIPO in Geneva a number of times, and our judgments basically were read by the various courts of India, various courts of the world, but are also being appreciated even as of today. So at that time, government noticed that we should basically repeal the thing. We should simplify the thing on the basis of the judgments already granted by the High Court and Supreme Court. So this is a very unique thing that judgment were passed in 1969, the judgment were passed in 1960, the judgment was passed in 1992, the judgment was passed in 1993. All the judgments were read by the expert committee, and ultimately the new act came. The act of 1958 was repealed and new act came in 99, and it was basically effective from 15 September 2002. So when the 2002 came, the committee at that time amended all the provisions, section definition of the trademark, section 9, section 11, section 28, 29, and lot of things has happened at that time, which are basically first time in the world that the judgments are given in prior in time, and the amendment came later on. And service mark was added on the basis of the Ellora judgment and many other judgment at that time. They say basically even somebody will use the trademark of the other side as a part of the trading style, even then basically it is a case of infringement, not it's in a case of passing off. The service mark was added, and color combination was also added at that time, although it was the subject, to some extent it was the subject matter of copyright also, but they say it will be a trademark also, and shape of the goods also. Shape of the goods was also added in the definition. The concept of well-known trademark was introduced, and different goods concept was also added in section 29 subsection 4. And for service mark as a corporate name somebody using, that is 29 sub rule 5. So on the basis of the judgment, in the basis of the landmark judgment, the order were passed. And after 99 Act came, which basically effective from 2002, lot of thing has happened, lot of more progress, more growth, and you will come to know that in one of the case, one more thing was added, because if we go to the court, whether it is Ahmedabad court or Bombay High Court or Delhi High Court, the judge's mindset was little bit very limited. They were saying still basically old time. They say no, basically sometimes they pick Evidence Act, sometimes they pick Specific Relief Act. Because Specific Relief Act says that if there is an equitable right, injunction should not be granted. Section 14 and Section 41 of the Specific Relief. Still, basically, there was a dilemma. So, Parliament at that time in 99 Act added one para in Section 135 of the Trademark Act. So, they say even because they were not granting the ex parte order, if the ex parte order is not granted in trademark matter in a good cases, then basically defendant will come and he will take all the objection under the sky. So ex parte provision was added in 135, which says that the court will grant in an action for infringement ex parte order and also appoint the local commissioner as well as attachment order against the infringing parties. So earlier basically on the basis of oral submission, these orders being passed, and under section 39 rule 1 and 2, sometime ex parte is granted, sometime it was not granted. This matter basically was discussed by the Supreme Court, and my friend is here, my senior counsel, Mr. Trivedi actually brought that Lakshmikant Patel case in the Supreme Court, and he successfully lost in 3 courts. But matter went to the Supreme Court, and when the Supreme Court saw the section 135 that the ex parte injunction should be granted, so we were thinking that there is a concurrent finding of 3 courts, the judge will decide in 1 minute, he will simply dismiss it. But the judge was very serious. He said no, because the law is not changed, mens rea is not required, actual deception is not required. Simply, basically, how can they use the same trademark And why the injunction should not be granted? He said the court has given the finding in Lakshmikant Patel case that the concept of concurrent finding by 2 courts or by 3 courts totally irrelevant if those judgments are against the law. Second concept, the Supreme Court in that case decided about section 135. They say in trademark matter ex parte injunction should be granted and local commission should all. It was first time discussed in Lakshmikant Patel case, and ultimately this thing is coming. If you see the trademark judgment after 2001, when the Lakshmikant Patel judgment was there, at that time the act was passed but it was not effective. But the Supreme Court, on the basis of the draft bill, they basically observe all these things in the Lakshmikant Patel case. Now, there was no limit thereafter, because in trademark matter, even the defendant is aware that he is copying it. Plaintiff is also aware that I have a good case or bad case. Thousands of judgments have been passed. Even today, the position is that unless some technical issue is there, some important matter is there, normally plaintiff knows his case, defendant knows his case. If basically any notice is given, many cases the defendant will come and settle the matter in view of the settled law. In view of the settled law. Now, I don't know whether slides are there or not. Slide, I have just basically sent few slides to Mr. Sarthi. Achha, Sarthi. Here. I will just give you a few examples, then I will finish. Oh. आ गया? Slide 1. I will just say the important thing. This one. This one you just see. This is a case of the party John Deere. Here basically this case was filed after 99 Act. This was basically here from Gujarat. Somebody was importing tractors. They were dealing in agriculture implements. And his case was before the court that we are using a green colored tractor which has a special face and yellow color ships, and this color scheme is become very distinctive, which comes under the definition of trademark, section 2M of the Trademark Act. And ultimately the injunction was passed in the matter. Matter went to the division bench. The division bench has also confirmed the order of the single bench. So you can see the development. In normal course, if somebody will use the green color tractor, everybody will say, no, it's a very common color, anybody can use it. But court said no, because whether it is a single color or whether it is a 2 color, it is a distinctive colors which have been used in India first time by John Deere. Though basically the injunction should be granted. Injunction was granted. Now, second is, if we see, this is patent filing. Just see, in 2014 we just filed 42,854 applications, and if you see 2023, the total applications are filed 90,309. So it shows that how much progress, and these are the patent applications were accepted. And here the court says the Government of India only 10 days back has issued the notification. They say that artificial intelligence needs no registration. It will cover under the Copyright Act. So this article is there. You can have the copy if you like. This separate registration not require. Whatever is a copyright law is there, it will definitely apply in artificial intelligent cases also. So this is a case decided by the High Court, decreed the suit. If you see that only basically shape of the goods were same, trademarks were different, even color scheme also to some extent was different, and ultimately the injunction was granted. 2 cases were filed, and ultimately both the cases were decreed. Now, at this moment, I can only tell you that lastly I am just telling you that all the record in the trademark office, controller office, copyright office, all the high courts digitize, all the high courts are hearing online, and it is a new achievement, maybe because of COVID, and maximum disposal are there in various high courts. And in some of the high court, we don't have the IP division, or it has been recently established. I am very much hopeful that after 1 year or after six months or so, even basically I've talked to the sitting judge of the Bombay High Court. He says, I say, if you need my help, I will come there. And you must basically try that all the cases can be disposed of which are left by the IPAB. And they are trying their best. And I'm very much hopeful that after some time you will find that IP division will also work in the same manner as IPAB. Now, I met the minister also, Industry Minister Piyush Goyal, maybe 6-7 months back. There was some IP day in the High Court itself. He basically mentioned to me as well as to the public. I met separately also. He says that I will see that in all the trademark office, we are creating the system that no advocate will go to the trademark office. Everything will be online, and online hearing will be conducted online, argument will be addressed online. And I can tell you, we may not be in the first 2-3 list, maybe 6-7 in the entire world in IP cases, in view of lot of growth, in view of established system. But I am hopeful that after 2-3 years you will see that we may be in the first 2-3 numbers in the entire world. Thank you so much for listening me. I am grateful to everybody. Thank you.
Good evening. On behalf of Organizing Committee and the Ahmedabad Management Association, I extend sincere gratitude to each one of you for gracing the 7th IP Summit with your presence and active participation. We express our deepest appreciation to our esteemed chief guest, Mr. Manmohan Singh, retired judge of the Delhi High Court and former chairman of Intellectual Property Appellate Board, whose insightful words have truly enriched our event. Respected sir has a wide experience on the advocacy as well as on the adjudication side. And it is indeed our utmost pleasure to have a stalwart like him as our chief guest. Not only that, sir, sailed us through various case laws which establish the Trademark Act of 1999, which came in place, and how everything, all different case navigated through. In fact, not only that, sir also mentioned about the patent filing, its progress, its speedy disposal, which is the current trend and current talk of the town across the nation, in fact. And sir mentioned about certain design case laws, which is also, a part of one of the regime of intellectual property rights. Not only that, recent developments, as sir rightly mentioned about how government is, sincere or keen about taking the speedy disposals of IP-related cases. Sir, thank you so much for your words of wisdom, and your rich experience has definitely helped us. Now I'm taking this event ahead. We have 2 panels lined up. So 2 panels have been designed. The first panel talks about IP generation and monetizing strategies, wherein the segments which are incorporated are sports, entertainment, and automobile. We have brilliant speakers with us, with brilliant moderator, Mr. Anubhav Kapoor. I would like to introduce him. Mr. Anubhav Kapoor has 27 years of in-house experience with consistent achievement while serving as key member and advisor to executive management, implementing strategic business growth initiatives, managing through crisis and change, and overseeing all aspects of corporate governance and corporate legal function with global responsibilities. The work experience with companies engaged in information technology, BFSI, software, food, pharmaceuticals, manufacturing and engineering services, in automotive, aerospace and industrial machinery. I welcome Anubhav Kapoor to be the moderator of the first panel. And before we start the second panel, I would also like to introduce our second moderator, Dr. Nidhi Buj. Okay, so I would rather invite my panelist, and thank you, Dr. Jaimin Vasa, to be here. And okay, my panelist, Mr. Suryadeep Basia, Ms. Bindi Urvi Shah, and Mr. Nishant Shokan. Please, I welcome you all on this dais.
Hi, good evening, everyone, and thank you, AMA. It's always a privilege to be back. I've been associated with AMA for many years now, so it's like kind of a homecoming now, and to be part of the family and meet all of you every year. And thank you, YJ Saab, Jatin Bhai, and Gopi ji for having me here, and all my esteemed colleagues on and off the dais. It was a privilege to hear Justice Manmohan saying, and sitting next to YJ, right? So YJ Saab and both go back 60 years, and probably many of the landmark judgments that you just heard of were kind of done together, right? So it just felt like we are just learners in front of them, and when both of them, such luminaries were sitting and speaking to and sharing their knowledge today. But moving forward, I would also want to compliment AMA for bringing in such an interesting format, right? All our earlier years were all about telling or sharing our technical knowledge about IP, right? But today is the real test when the tire hits the road, because here is, you heard the legal version of how IP works, right? And it is said, creativity is the fuel for innovation, and IP is how you protect innovation, right? And that you heard from Justice Manmohan Singh, the law, and it was a crash course of IP history in the last 70 years, or I think more than 100 years. But today also we have on the dais 3 industry experts who run companies or startups based on IP, right? So here is where the technical knowledge and how it applies in the real world is going to meet together, right? And I think this is going to be a very interesting session as they share their experiences in terms of how they were able to monetize IP, and that's the session we are in, IP monetization, right? So I already told you what IP was, but for a layman, what is monetization, right? So imagine a company. So at the top of it, we talk about IP and we relate more to trademarks, copyrights, patents, trade secrets, right? But that's just the tip of the iceberg if you talk about intellectual capital of a company, right? Because there is so much more down as intellectual capital that we can talk about. Say, for example, brand name, right? Or brand value, your list of suppliers, your know-how, your technical knowledge. In fact, in an IT company, every day your intellectual capital is in form of employees go out and go into the company. I think it's the whole set of all that form the intellectual capital or the intangible assets of your company, right? So in very layman terms, monetization is the process where intangible assets are converted to tangible assets like cash, property, etc., right? So we basically are on a journey where IP is converted into cash. So this is what the subject in short is going to be today. And to start with, let me give you an example. Say you are hungry, right? And you are feeling like you want to have a pizza today, right? And you go to Zomato or Swiggy and you want to order a pizza, right? So you log in and you see lot of choices, right? Which are the popular pizza guys? Domino's Pizza, Pizza Hut, Giuliano, Papa John's. Any other favorites? Huh? Papa John's. Okay, Pizzas. Okay, so you have all these pizza companies coming there, right? And while you are going through, you are recollecting the experience you had last time when you consumed their product, right? And maybe it is in form of certain memories, in form of certain taste still lingering in your head, right? But that's it. And based on that, say for example, you choose a Domino's pizza, right? So you click Domino's Pizza and you see their distinctive red and blue square, correct? That's the Domino's. So you go through their menu and it has some very distinctive pizza like Peppy Paneer, Farmhouse, Pizza, Meat Lover Paradise or something like that, right? So there are certain set of pizzas which are there. So you recollect that last time when you ordered, this particular pizza had also this kind of a flavor, right? And then you also remember, okay, let me do that. But then also you want to know which is the nearest store that you have in the neighborhood, because it may be a good idea to walk down there and have the pizza and not simply order it at home. So you look for their helpline and it says 1-800-280-1234 and you dial it and they say, it straightway goes to the call center. It asks you where you're from and connects you to the nearest pizza store which is in your locality. That's how it happens. So you connect to that store and they ask you your phone number, right? So you give your phone number and the voice on the other end says, welcome so-and-so, what would you like to have today? Last time you ordered this, right? And you place your order, right? And once you place the order, and then you start waiting for the pizza, and many times you're looking at the watch that if these guys delayed more than 30 minutes, you're going to have a free pizza, right? So that's what their entire thing is. Now on the other side, at the pizza store, there is this franchise sitting there, franchisee, right? He has opened a pizza store as a franchisor, and franchisor is nothing but he's obtained the know-how from Domino's International. He has learned from them how to make pizzas, and based on that knowledge and equipment, he is making pizzas which look like Domino's, because one of the things for these large chain is like McDonald's or Domino's is that anywhere you go and everywhere you go, the pizza tastes the same, right? And obviously if it tastes the same, then there must be some know-how, right? Which is uniformly applied again and again and again so that the same kind of pizza goes out, correct? So here is this guy, and he has to pay something for that know-how, right? But forget it. Now there's a guy, he says you ordered Pepi Paneer, right? And he announces Pepi Paneer, 1 pizza, right? And here's this guy who takes out a fresh ball of dough, which has come from some remote kitchen of Domino's. He slaps it up, puts a red tomato sauce, which is proprietary. Nobody knows the secret of that tomato sauce. He puts cheese and vegetables, and then he puts that proprietary Pepi Paneer topping, right? That yellow cubes of paneer coated in a certain marinade, right? You don't know what it is, but it tastes the same every time, right? And even if you go to the store, it comes in cans, which doesn't tell you what the ingredients are, right? So here is your Pepi Paneer. So he puts it in the oven, it gets cooked for a certain amount of time, and the same quality pizza comes out. There are so standard same boxes every time you get your hot pizza, and it's delivered to you in 30 minutes, right? So this is the process how you get the pizza. Can you tell me how many IPs you have used in the process? Think about it. The first you called, there is a number 1800, that's a IP, right? Nobody shares a number. So data sets are IP, your intellectual capital, right? So you call them, you ordered a pizza, their menu is a data set. That's a IP, right? The recipe is a IP, your phone numbers are IP, your name is a IP, right? The way your telephone numbers are all part of their database, which is valuable, right? So think in that way, then end to end, the whole process that I narrated basically has more than 50 IP points. Count it and you come back after the session to me, right? So that's the magic of IP. Now, in the end, a good mixture of vegetables, dough got converted into pizza, which is hard cash. Each pizza costs you about 500 rupees. That's when I say a know-how of making a pizza, a IP, a intangible asset got converted to tangible asset, which is cash, and it rings the counters. Got the example? So here are my esteemed guests today who will tell you this secret, how they make their intangibles into assets, correct? So we have Suryadeep Basia. He is head of Gujarati category of Shemaru Entertainment. So Shemaru is supposed to be one of the firms which holds the highest number of copyrights for film content, right? He's a co-founder and chief executive officer of Oho Gujarati. He, of course, runs a production company and he's head of business development. So he's the guy you can ask any question on how media makes money, right? So even your selfies are valuable. Don't spoil them, right? I'll tell you a story how a photograph of a monkey was sold for millions of dollars, right? But that is at the end. Then we have Mrs. Bindi Urvashi Shah. She's the founder of BU4 Auto Electric Scooters and Bikes. And she's also a partner of Riva Autolink Passenger Vehicle Dealer of Tata Motors. So she's the person from the automobile industry. So how do you make money in automobile industry? She's going to share with you. And she's also received a number of prestigious awards. I think the more recent one was Gujarat CM, Mr. Bhupendra Patel facilitated her as a Pride of Society by Indian Council of Social Welfare. And she's been invited at different forums. One, she's a woman entrepreneur, so even more important. Then we have Nishant Shiokhand. He's an accomplished international sports lawyer, founder of Football Legal India. In consulting with sports organizations worldwide, his extensive experience includes collaborating with renowned entities such as Football Club of Barcelona, one of the world's largest club. And of course, he's now a professor of law and associate dean at VMLS and has a very interesting career. He will tell us how law, sports, and money goes hand in hand, right? So here's the panel for you, and I'll start first asking Nishant that how do sport franchises leverage intellectual property generation strategies to build and enhance their brand image? No, you can pick up the mic there. They are working.
Can you guys hear me over the mic? Yeah. Okay. First of all, thank you so much, sir, for the wonderful introduction, and also congratulations to the organizers today, YJ Trivedi and Co, and also AMA for organizing such a wonderful event. If I were to talk about sports and how it interjects or interacts with IP, more than going into the strategies today of how we monetize over it, I would definitely like to go into how we stop the non-partners from monetizing over the IP any sport event or any sports organization has created, and the kind of money which is involved, the strategies which are involved with it. And it would be also interesting to see, let's say, how the technology or the advancements in the technology is giving rise to a very new line of sports practice, which is technology doping, right? We usually, whenever we talk about doping, it's usually related to any chemical which is involved. But nowadays, it is because of the advancement of the technology that we have come up with a different line, which is technology doping, which also interacts with how IP is controlling it and how all of it is legal. It will definitely get into certain examples of your 2023 very expected World Cup for India to win, but I am sure a lot of hearts were broken that day when India ended up losing to Australia right here in Ahmedabad. With that, I think we can then move towards certain questions if we have any. Otherwise,
Thank you, Nishant. I go next to the automobile industry, and in automobile industry, IP generation extends across patents for technological advancements, design patents, trademarks, brand recognitions. I think I've been working in automobile for quite a long time, but I'll ask Bindi that how do automobile manufacturers utilize intellectual property generation strategies such as patents and design patents to foster innovation in the industry?
Sure, sir. Thank you so much for the introduction. And thank you, AMA, for inviting and having me here. I'm Bindi Shah, founder of BU4 Auto. We manufacture scooters, electric motor vehicle, and electric bikes. Our latest innovation is Euro electric motorcycle. Represent a significant milestone for us. We have recently completed the patenting process for the several of its components. And I would like to highlight why intellectual property is crucial, especially from the customer's perspective. Firstly, our focus is on delivering exceptional products that delight our customers. We want them to feel sense of pride, uniqueness, and when using our product. By securing patents for our components, we ensure that our offerings are special and not commonly available elsewhere. This uniqueness sets apart from our components and ensures that our customer have an exclusive experience. Secondly, having patent components open up the opportunity for a collaboration for the other brands. Companies interested in using our patented technology can do so through licensing agreements, allowing us to earn royalties. This collaborative approach not only generates additional revenue, but also expand our brand to reach and influence in the market. Lastly, robust intellectual property portfolio, including patents and design patents, enhance our reputation and value in the eye of investor and stakeholders. This credit attracts investment for the further research and development. that this innovation pushed the boundaries for the automotive technology. In conclusion, intellectual property plays a crucial role in our journey. Actually, this gives a trust to the customer, to us also. This saves our money, what we invested crores of rupees in the research, developing, designing, and all. So this way, this IP is more important for us and to others also.
Thank you, Bindi. That was very
Thank you very
insightful. Abhishek, over to you. In your industry, how do content creators in the entertainment industry utilize intellectual property?
So, sorry, before going into that, Abhishek, my name is Suryadeep. So, Abhishek, when he called me yesterday, would you want to speak here? That was a very odd moment for me. 4 years back, we founded an app called Oho Gujarati. Me and my co-founders, we got very excited. Okay, we want to found an app and we want to do this and do that and all of that. We started the app, we put in content, we got subscribers. Post that, we realized we can't have a trademark on Oho. And that is when we approached Jatin sir's firm, and they are the ones who stepped in and got us the trademark. So now coming here and speaking IP and trademark in front of him, that's a very odd moment for me. So I feel like a fish out of water, but I'll try my best. On to monetization, interestingly, what has happened, even if you speak like right now, I'm working for Shemaroo, and few years back when we have a repertoire of about 1,400 films for which we own negatives, and we syndicate, distribute and monetize those content pieces across platforms. So whenever we used to go to buy content, it was always supposed to be negative rights. Okay, there's only one term, and that was negative rights, and that term came from films used to be shot on reels. Okay, so your producer would come and put the reel down, which is called a negative. And then I can monetize it, distribute it, syndicate it the way I want across platforms. With the onset of digital, that has changed completely. Now, when we sit on to discussing IP, we talk about satellite rights, we talk about digital rights, we talk about DTH, we talk about airborne, we talk about seaborne, and multiple ways. So as producers, we have multiple platforms and multiple revenue streams that we can monetize. Going forward, that is, again, AI is going to change that as well. So just last month, I was talking to a AI company in Bangalore, wherein what they do is, as a producer, I've produced a film. I need to send the film to those guys. They will scan the entire film, and wherever an actor, let's say he's wearing a certain piece of brand shirt, as soon as that shot will come onto the frame, they'll have an Amazon link there. You click on the link and you can buy that shirt. And that will be a seamless process. So whenever that's another revenue stream wherein producers will be able to monetize content going in the future. Yeah, interesting times.
Very, very interesting how the whole world has changed, right? I still remember as a child, I used to go to a movie hall, and half of the time I was not looking at the screen, but looking at the guy who was running the projector, right? Because that was so interesting, because the boxes would come and he would put the spool there, and there was a certain noise which went along with that, right? And it was so characteristic of remembering the movies in those days. And yes, now everything is digital, right? And coming back, Bindi, on the patents, I still remember the first time we made a prototype for Nano in Tata's, and we were able to, in the first prototype, get 42 patents out of it, right? And Mr. Tata had a vision for that car, right? I think most of you would know the story that he saw a family of 4 going in rains on a scooter. So he wanted to give the nation a car which was affordable, right? And he said, I take the challenge of making a 1 lakh car for the masses, and it was produced right here in your neighborhood in Sanand, right? Now, if you have noticed Nano, it had many unique innovations. Now, a car has to be street legal, right? So under the Motor Vehicles Act, there are many safety standards you have to qualify before you can have the car on the road, which is kind of motorable, right? So if you saw in a Nano car, there were only 3 bolts on the wheel. Did you notice that? Normally a car would have 4 or 5, right? Nano had 3. So we had to save cost. So it went to that kind of a detail that without compromising the safety standards, we were trying to save one bolt of one wheel, which is like 4 bolts. And if you add it up in the number of cars, then probably the saving was huge. Similarly, if you see the wiper, right? Usually cars would have 2 wipers. It was the first time Nano had a single wiper, right? It was a longer one, but it has a special innovation. It bended, right? So in a flash, the upper portion would go down, because one of the safety standard is that you cannot have a wiper should clean more than 80% of the front glass, right? So you cannot have a wiper design which doesn't do that. It will never be fitted in a car. So it had a 2-piece wiper, but a single one, which saved cost. Similarly, the seats, it were made of coconut coir, right? Never ever it has been done, right? I can go on in terms of how much innovation that car had. I think rest is history, what happened to the car. That takes me to the brand names, right? Because Nano got associated with a 1 lakh car, right? I think that was the day people called it a 1 lakh car, it actually sealed its destiny, right? And that takes me to the next question of brand names, right? So let me start with Abhishek. What role do trademarks and logos and team names, trademark and logo play in the media industry, and especially copyrights as well?
So I think that's the beginning of any film. And as soon as you have an idea, the first thing that should ideally be done is you copyright you copyright the content piece. You send it to SWA, you get it, copyright registered, and then share it with studios and production houses. Right now we are at 3 unique stages. First one being wherein I work partly in the Gujarati industry, wherein I get hundreds and hundreds of concepts every month, which are not even registered. And that is a very, very slippery slope for us as well, and the writers as well. While the Hindi industry is a bit more evolved, wherein they do register their scripts, they do register concepts, they understand the value of IP and IP creation, but that still is not the ideal stage. If you go to the US, studios will not read even a registered script. They'll say we'll not read it, they'll delete it. So you will have to go through an authorized agent or a law firm that is representing the studio, and only through them they'll read the scripts. Because let's say I got a script which is registered and which has a character called Anubhav, right? And I'm not making that film, okay? I've passed on that film. After 4 years, it's a completely different script, it's a completely different film, and my character name's Anubhav. The original writer can come back and tell me, okay, you have used my character and you'll need licensing rights from me. So it's as complicated as that. But yeah, we are evolving, we are learning. Even the Gujarati industry is learning. And hopefully we change.
So how do you register a name? Like there was Janjeer, Amitabh Bachchan's Janjeer, right? And then there was a remake of Janjeer, and somebody took the same name.
Yes.
So, but it wasn't a violation. So
no, it is not.
So you registered. The finding names is so difficult, and I'm sure all the strange movie names we have now are because there are no names left now.
Right.
But still, people are able to find a name. So how does this whole thing work?
So it's done in 2 parts.
And basically. It is copyright, right?
Yes.
Basically, that's your trademark also. And your copyright.
Right. So it is done in 2 parts. One is you register your concept first, and that in majority of the cases will go untitled. Okay, it's said untitled. There's a brief content synopsis and your name and your SWA number, and it is registered. Then you can share it with n number of people. The title registration will probably happen at a very later stage.
Okay.
Movies made, or it's in the process of making, and you crack a title, and then you go and register the title. And then you basically leap on the IP. So Dawn as a title has been registered, and even now the IP is giving them value.
Correct.
Dawn bana, fir Dawn, Amitabh ka film tha, fir Shah Rukh made it, and it's even right now it's giving them
Royalty or something
It's
like that.
giving them royalty. In fact, Hollywood has been raving on that, right? They'll make a sequence because it is very easy for me to market. अगर मैं कोई नया film market कर रहा हूँ, that's a whole another ball game. But if I have a title that is already marketed, that is already sold once, it's very easy to sell. So there's marketing value, there's monetization value even on the name of the film.
And what about the remake of songs like this new movie which had this Bareilly ke Bazaar mein
Yes.
kind of mixed with few lines, and was it
So,
copyright okay?
Originally, the copyright used to lie with the producers, which, I mean, not fortunately for me, but fortunately for the composers, that has changed now. So most of the composers, when they make songs, they'll keep the copyright. And if I want a remix of that or remake of that, I either go to the composer, or if the composer has sold it to a label, I sublet it from the label. For even if I want to, let's say I'm making a film and I have a scene wherein I want to use 30 seconds of a retro song. I have to go to them, I have to license that song and then use it. So it could be with a label or it could be with a composer.
Yeah, it got us in a soup.
And Anubhav, can I add here?
Yeah,
So
please.
just like I think one of the recent examples could be from Forrest Gump, right? Where Amir Khan then remade the movie in Bollywood as well. I think it's called Lal Singh.
Lal Singh.
Lal Singh Chadda. Although it did not do that well compared to Forrest Gump, but it took Amir Khan almost 12 years to convince the makers of Forrest Gump to license the concept of the movie and even almost recreate the scenes from the movie in an Indian version, because they were worried how that particular concept would be copied in India and would be shown to the audience, and that is what ended up happening. The apprehensions the makers of Forrest Gump had, it sort of then resulted into the movie not doing well, because Forrest Gump ended up doing so well, I think, in the international market, not just in the Hollywood, right?
In fact, one of the most recent examples, there's a Hindi film coming on the 8th of March by Ajay Devgan. It's called Shaitan, and that is a remake of a Gujarati title. So
So you guys are sued?
yeah.
You sued?
No, it's an official remake.
Okay.
It's an official remake. It's an official remake. So yeah, but Shemaru has the title. So they're making an official remake. It's called Shaitan.
But this put me in a lot of trouble. I remember I was in Cummins and we were practicing for our annual day, right? So obviously companies have very young people, right? And we had this bunch of really very energetic girls who were practicing a song on a Bollywood number, and they just took a small video and posted it on YouTube, right? So I think after 45 days, we got a notice from PPP that this is a public performance of the song. And they wanted us to pay some lakhs of rupees as a license fee for playing that song, and what happened after is a different story, but that's how sensitive this is. So one of the lessons we learned is, please do not, you can hear your songs, but you have to make this distinction of private listening and public performance, right? The moment you cross this thin line of public performance, you are supposed to pay a license fee, right? But so thank you for bringing that up. And that takes me to Bindi. How Bindi, does the trademarks play a role in automotive?
The trademark in automotive is very not much different, but yeah, we design, we publicity, lot of part is involved, lot of money is involved. So trademark is very much important for us also, because we have invested a lot of and crores of rupees for just designing and just making this particular product. So once, if it is in market, when we started marketing, when we started publishing the photos and videos, and also anyone can copy it, and there is no value of your product. So before you are launching the product, when you are making that product, you have to patent that.
Oh, so what is the name of your bike?
Sorry?
What is the brand name you are using?
Euron.
Euron. How did you come with that name?
That is come with from my husband's name actually.
Oh, you put your husband's name on the bike, huh?
His name
He
is
is very
Urvesh
lucky,
and
huh?
he love iron. So it is combination of Urvesh and iron is commanded Uron.
Okay, but before you registered that trademark, did you do some kind of a search?
Yes, we even the registering the brand name BU4 with the company name, we even the register because BU4 it is actually a family name which start from me Bindi, Urvesh and V4 of family by 2 childrens. So that
Okay.
is we wanted to have the create the company, but before you, if you remember, that's before you music company is also there. They are publishing. So there is a very similarity between the name. So when we are starting the patenting process, we come with a lot of companies who come with this patent and name and registration. But yeah, in a automotive there is no name. So thank God we got this name. We patent, we register, we got a trademark of the name, and how this process with the company. Then we started initially with this particular bike, particular product, and then we come with a lot of thing.
Did you get any notice that you copied someone's name?
No, not yet.
Not yet, huh?
Yeah.
Oh, you're lucky. Great. I think that is what branding plays a role, right? Because I think Nano, let me come back to Nano, right? Nano got associated with 1 lakh car. And in India, a car is a status symbol, right? The moment you drove a Vano, it represented a 1 lakh car. People did not see the innovation. People did not see what a technical challenge it was to bring that product into the market, what kind of efforts, what kind of Indianness, what kind of Tata-ness went back into that product, but they associated with a status symbol, and that product is no longer in the market. A sad story, but that is how brands are important, right? The brands create perception of a product, right? And if the perception of a product is not correct, and if you can't generate value out of your brands, that's a big mistake, right? Or that will hit you somewhere as you move towards your entrepreneurial journey, right? So that is how important the trademarks are. And so let me go and switch gears. One of the ways you can make also money is licensing, right? I talked about franchising, right? Franchising also is a kind of licensing. But let me not dwell too much into it, but ask Bindi in terms of how does licensing technologies help manufacturers, and they help you form partnerships and alliances.
In licensing technology, we offer the franchisor to use our logo. We ask them, they can use our logo, they can use our color of the what we pattern for the logo. They can use what our designing for the showrooms, displays, and all the other amenities.
Okay. So did you license any technologies?
We license the technology. I think the Urvesh can tell me the more.
Okay.
If you don't mind, yeah. So we have already applied licensing for the entire design of the motorcycle, and along with it, we are also licensing the controller, the motor, BMS, the alloy design, the cluster panel, and of course the overall bike design, the swing arm, everything we are patenting separately, even the headlamps. Because our headlamps, we had the issue that when we were trying to get it patent and license, so at that time it was very close to Ducati's headlamps, and certain portion like the swing arm was very close to the KTM swing arm. So we had to ensure that our designing slightly separate, and then we rechanged our designing, and then we applied for the patent. Same was the case for the name registration. We got a lot of, because we have a legal team which does this. So before applying or getting into it, you need to check all India and all the places that is this name used or anybody is using it. So for Euron, when we applied, we got objections from few pharma companies it was UTech and some other was very close to the Euron, and they objected, and then it was overruled, and then we went forward to register the brand name. Yeah, BU4 was simple, it was done, and still we are on the way of patterning the motorcycle. It's under examination, the designing, the parts and everything. Soon we'll get the certification for it.
Since you've gone through the journey, are there any learnings you want to share with the other entrepreneurs in the audience?
So
of course,
I-
you need a good lawyer, I can tell you
Of course,
that.
yes. So you need a legal a lawyer who will guide you for all these processes. It's very important because just she rightly said that you spend crores of rupees because automobile is something that you are when you are touching the aspiration of young generation where we are making motorcycle. So when you are making that, so you need to apply a lot of brain, a lot of analysis, a lot of money is spent. Now you make it and somebody is already there with it, or somebody will replicate immediately after seeing that. So your hopes are lost. Customer will feel that who is original. So it is always better to have an intellectual property before going into the market, so that you are secured. You know, today if anybody copies, you just said that. I think sir said for Mercedes-Benz case. So there are such lot of cases because I am again a dealer of Tata Motors. So I know that in recent past, before 15 years, Sonata had the same problem. They had got a legal suit from Mercedes for Jaguar for their look of the car. So they had to discontinue that model. So this is very important. It started selling really good, and then Jaguar had sued them, and they had to change it. So
Thank
it's very
you.
important.
Thank you.
Thank you.
Thank you for sharing that. So I move to Nishant. Nishant, for your industry, right? How do trademark, logos, team names, even licensing rights, right? How do they play a role? Because a lot of merchandising happens and they're all licensing based. So please share your experience and
Thank you. So definitely, when we talk about the sports industry, right, it's quite peculiar if we compare it to, for example, automobile or in fact media. Although we are a bit similar to media, but works very differently. And where does the difference lie? Usually, the difference lies in terms of how we intend to protect the infringement of, let's say, any of the intellectual property rights which exist. I'll take one very recent example where my organization had the wonderful opportunity to work with International Cricket Council, where we collaborated with them for the recent World Cup which happened in India. So as we are based out of Chennai, so our job was to be present in Chepauk Stadium for the 5 matches which were happening. And India's first match was supposed to happen in Chepauk, right, where India ended up playing first match with Australia and we won. So there one very interesting incident happened with my team where we were tasked, let me first explain how things happen in a big sporting event, right? In a big sporting event, there are various organizations coming together, be it sponsors, be it any sporting organization which is there, and obviously the International Council which is governing that particular sport. In that, the foremost responsibility of the organizers is to stop any right infringement from happening. So how do we do that? One, obviously at the legal level, but second becomes at the ground level where you are physically present in the stadium and your team is spread out. Your team is spread out and trying to stop each and every kind of infringement which is happening. For example, there would be people sitting with hidden GoPro cameras and trying to live stream the match. There would be people trying to pass off their fake products as original merchandise which is there in and also around the stadium. Then you have people who are into the gambling industry. Because your telecast, correct me if I'm wrong, is 12 seconds late what is shown to you. It's not live. There's a 12-second lapse or gap between the live and what is being shown to us on TV. Or even, in fact, for example, Disney Plus, right? We are a bit behind in that. So what they're trying to do is they're sitting with multiple phones there and trying to update the score live so that whoever is betting on a match, they can do it with more information compared to anyone else who is just using the live telecast which is there. So as the team of lawyers, as the team of spotters, we are coupled with then the police officers. I was also talking to, let's say, fellow panel members before the talk, where our job becomes to spot these people, then run after them. Like, just imagine the team of lawyers running after these people, catching hold of them that, okay, this is something not allowed, you can't do that. And in that, what happened, India was playing Australia, and my team of students, they were running after a few people who were wearing blue jersey, but was not official merchandise. So what happened, as soon as they saw us with the police officer, because the power also has been given us to arrest those people on the spot, right? So my team started running behind them. The guy was running and he was wearing a blue jersey. So what happened, at the same time, Kuldeep Yadav was also coming out from the dressing room. So instead of jumping on the guy who was wearing the blue jersey, my team ended up apprehending Kuldeep Yadav for let's say, passing or let's say selling fake merchandise, although like that was resolved quickly. But that is just one of those examples of the kind of work as IP lawyers. Although I'm not an IP professional, more of a sports lawyer, where we end up doing this kind of work. But this just gives you a taste of the work you have to do on the spot. And I'm sure the similar kind of team was there in Ahmedabad, was there in Mumbai. Wherever any match is happening, you have to make sure in and around the stadium anything like this is not happening, because as you are aware, there are multiple contracts, agreements in place to make sure if Nike is sponsoring the event, no Adidas banner can be seen in the crowd, right? And to stop that, you can't just make agreements, you have to be there on the spot and stop that ambush marketing. Ambush marketing is, what would I say, a hassle for big sporting events, because 90% of the revenue which is generated for sports is the live telecast and the sponsorship which comes in.
Thank you, Nishant. And what I think you gave me some good tips of this 12-second laps. So remember that. So what do you think this whole virtual reality and augmented reality? Justice Manmohan Singh also touched on the AI part of it. How is it being incorporated into your sports domain, and how is it helping you?
So here I would like to bring in one of, like you mentioned when you were introducing me, that I had the fortunate to work for Football Club Barcelona. So they have this innovation hub called Barca Innovation Hub. So the kind of work they are doing there is amazing. It's like from talking about, I'll bring in one more example of Nike here. So Nike is responsible for the technology doping which is happening. So Nike recently came out with a brilliant shoe which to an extent of 4% increases your output as a long distance runner. Okay, so if you look at 15 years track record of 5 kilometers and more track and field events, a lot of records have been broken. And those records have been broken because of the super shoe which has been worn by the athlete. And later on it came into question why a shoe like this is allowed to be worn in an international event, because the name of the shoe is Nike Vaporfly 4%. The name is itself indicates that you can go up to 4%. Basically, what does it do? It has a particular form and also carbon fiber which sort of distributes the energy back to the runner, and they are able to perform 4% better than they would actually do without the shoe. Right. So now just imagine a fan sitting in virtual reality who absolutely loves the athlete and wants to be like the athlete. In virtual reality, what happens? You're sitting with your VR goggles and that shoe will pop out from the runner's feet. It will come in front of you, it will revolve in 360 degree, and it will show you everything which is there, including the athlete's name, including the customized strips of his or her, let's say the country. For India, it would be the tricolored flag on your shoe, right? Now, do you have to do anything else to sell your shoe? The fan automatically on the spot is sold to invest into a shoe like that. And similarly, then Adidas also sort of enter the market with a super shoe. Now they have gone ahead of Vaporfly. It is Alpha Fly 2, which is now going to come into, and they claim that it would be either 6% or more than 6% of your performance enhancement, which is happening. And not just that. Like I think one of the panel members mentioned, where how it is not just limited to the TV now. There are different versions of how you can consume sports. They are there. For example, the small bites of a particular match, immediacy of the sporting events. How is it happening? It is happening because either you will go to the stadium and watch it. That also is where, for example, I'm sitting here, as soon as there is one interval, as soon as there is a gap between the overs, again, the marketing of the products, marketing of any or every merchandise which is involved will start around me. I can order everything which will come to my seat where I'm sitting in the middle. Again, my seat will go up. I'm talking about Barcelona here, where my seat will go up. It will turn into a spa, and right there, Messi is playing. I am here as a fan, and I'm let's say enjoying the spa right there. And obviously, as a fan, to get that experience, I would be inclined to pay more. And that's how. This is just one of the, I think, not even 1% example of how any sporting organization in the world is able to monetize over by first creating that particular model and then monetize over that particular model of fan experience. Either you are sitting in the stadium or you are sitting at the, let's say, in your home, comfort of your home. And as we know, most of our audience is Generation Z. And how do you catch their attention? You cannot make sure that everyone is coming to the stadium.
I think let's stop at the spa experience, right? Let it linger for a while. I'm still there. So thank you, ladies and gentlemen, for such an interesting session. I think I'll leave here. Leaving all of you in this spa environment where you are watching your favorite star and you are in a spa, but also with one question for Suryadeep for dinner, right? You can ask him that if this virtual reality goes so cool, we may not have real life heroes, right? We will only have those virtual heroes going in the future. And how's he protecting his industry from that, right? So I leave that the dinner question for all of you, but bring this session to an end here. And with this, we'll facilitate all our speakers. And this is a fabulous session, and thank you for your contribution. It's very, very interesting.
Hello. Thank you, Anubhav, Suryadeep, Bindi and Urvish, and Nishant for the very, very thought-provoking session. Now we switch to our next panel discussion, wherein we are going to talk about intellectual property and their implications of emerging technologies. So we have with us Dr. Nidhi Hriday Buch as our moderator. Nidhi is an associate professor of law, director, GNLU Center for Intellectual Property Rights at Gujarat National Law University. She has a very elaborate profile, but she has requested me not to, go through it. So let us welcome Nidhi with a huge round of applause. We have our panelist, Dr. Manish Shah, a renowned orthopedic surgeon. Then we have Ms. Lakshika Joshi, GC at Capgemini, and Mr. Sandeep Singh, CEO, Ishitwa Robotic Systems. Can we have all of them here with us? So I have the privilege to felicitate Ms. Nidhi, Dr. Nidhi rather. हाँ.
Thank you very much, Gopi. I think after the session that we had with Anubhav, he came and said that it was, then we had to tell him that there are two things. One, today dinner has to be pizza. You can eat nothing else, because the way in which he described in the beginning made all of us hungry. And second is that it was very, very interesting and thought-provoking. So then our session now will have to do better. We'll try our best though. The first session that we had was about monetization strategies in the upcoming field of sports, entertainment, and automobiles. The panel that we have and the distinguished speakers that I have with me will be talking about the implications of emerging technologies on intellectual property rights. In fact, when we talk about technology, especially emerging technologies, I think the significance of it is not required to be established anymore post-COVID, because we could survive the COVID only because of advancement in the technology. Otherwise, our real world would have never been converted into virtual world, and we would not have been sitting here, thankfully, without mask, thanks to vaccines. So the emerging technology definitely has become an inevitable part of our life. The relation, rather the interface that IP has with technology is inseparable and inevitable. IP means innovation. And when you talk about technology, you by necessary implication talk about innovation. So there is no way you can separate them, right? They are so interwoven and interconnected. When we talk about IP, we talk about IPR, and hence we essentially talk about IP law. All these things should come together, and they come together. So whatever little experience I have in the field of law, I say that law is not an action, it's a reaction. So the emerging technologies which are paving its way to success in all different domains require to be managed and handled very carefully. There's a delicate balance which is required to be maintained as far as the rights which are granted to these emerging technologies. So for that, we have most distinguished speakers among us, and they all come from such field that they themselves are involved in handling such kind of emerging technologies. Further, I would certainly thank YJ Trivedi AMA Academy for having people who are themselves are real stakeholders. Right? So I am there, that is how, as a moderator, that I don't have to talk a lot. And being a teacher, it's very hard not to talk. Initially, when we were talking that we will have 15 minutes, then they were like, 15 to bahut hai. I said, no, 15 is nothing. My introduction takes more than that in class, right? But then that's the reason Jatin Bhai has put me in this role. So I'll keep that in mind. And before I go ahead, give a introduction to my distinguished speakers and go to them with questions, I will perform the duty of felicitating them. Please, I'll start with Ms. Lakshika Joshi. I'll go to Dr. Manish Shah. And finally, I'll go to Sun. As I mentioned, I will quickly introduce the speakers, and then, without wasting much of time, I will then put few questions to them, one after the other. We'll start with Ms. Lakshika Joshi. She is a part of Capgemini Group IP office. She is into, in a way, consultation and policy making, one can say. She also has deep interest in sharing her practical knowledge and expertise, and that's how she is a guest faculty, and she takes up training program in intellectual property right at National Training Institute for Indian Foreign Services for those officers. She also conducts a certificate course in alternative dispute resolution in commercial IP disputes as an industry faculty for the Institute of Chartered Accountant of India, and she is a mentor of Atal Incubation Center of Dr. B.R. Ambedkar University, Delhi. Lakshika will be talking about how the technological implications on IP will help us understand the way in which things are taking place in the policy making, and especially the area from where she comes is something which is very important. It is all about semiconductor. So that is something which is very, very key in this age of emerging technology. We have the second distinguished panel with us, Dr. Manish Shah, who is actually doctor, not like me. He's an orthopedic surgeon, and sir has got certain patents in his name, and he's actually doing wonders with those patents and how that is bringing about some change in the healthcare sector. So he'll throw some light on that. And we have Mr. Sandeep Singh, who is CEO Ishitwa Robotic Systems, which is driven to solve one of the most pressing global challenge of dry waste using Industry 4.0 automation tool. And he strongly believes that AI and computer vision can bring affordable and scalable solutions to enable the circular economy of plastic. So prior to this initiative, he worked as private equity investor into the environmental and sustainable investment space, and his core focus areas were waste, recycling, and clean energy. With the 19 years of experience that he has working with startups from the early age of growth stage, he will be able to share with us his experience with the startup and how IP has played a role. Though he has given a disclaimer to me that he will not be talking about technicalities of IP, but of course his experience will definitely help us know how IP is an inseparable part of such kind of startups. So we'll start the round of questions, and I will first go to I think we start with Dr. Saab. I'll go to him first. And we will be talking about healthcare sector. And as I mentioned, due to COVID, we all know what changes are taking place. However, if we go a little deeper in it, we can say that as of now, the healthcare industry globally is undergoing a profound transformation thanks to the emerging technologies. This transformation has certainly brought about significant improvements in patient care and operational efficiency. These advancements also raise complex IP rights implications within the healthcare sector, because who will get the patent claim, how the patent are to be granted, and what system will help in it, because there are few things which are no more national, they go global. So how to find a way out. Of course, I will not definitely be technical as far as IP is concerned, sir, but the first, because you have already have some patent, so I would request you that you talk about that briefly. And then the question that I have for you is, how do wearable devices, remote monitoring technologies, and telemedicine innovations raise intellectual property concerns, and what strategies can be employed to protect the IP associated with these healthcare technologies?
To start off, first of all, a huge thank you to everyone for inviting me here. And I'll just give you a brief about the work that we have been doing so far. Everyone's heard of knee replacements and hip replacements. Essentially, what happens is that we take an off-the-shelf implant, which comes in fixed sizes, 1, 2, 3, 4, or ABCD. And approximate that in a particular patient. If I were to take the example of going out and buying shoes, when you go out to buy a shoe, normally what you look for is a fit. You know that maybe your size is size 10, but then not every size 10 will fit you perfectly. And the best thing that we do is we put the shoe on, walk a few steps, and then we know whether that size is perfect for us or not. Unfortunately for the knee or the hip or the shoulder, what happens is that the surgeon decides on table or preoperatively a particular brand that you've heard of or the relatives have used or someone else has talked about. You go with that particular brand, you approximate that size for yourself and put it on. It might not be an exact fit. The sad part is that even today, with advancing technology, about 20% of patients post replacements are not very happy about their replacements. That is how we got onto finding out what can we offer differently. So we created a software to perform virtual surgery, wherein from a CT scan, we would create a virtual 3D bone model. On that, we would mate different joints and see which fits the person or the individual perfectly. Thereby, we kind of ensuring that our satisfaction rates post-surgery would be close to 100. Thus, from a lot of available off-the-shelf implants, we could personalize an implant for an individual. Using that same digital technology, we were able to perform the surgery using specialized instruments that we created. So that is where the IP comes in. The first was the algorithm or the software. The second were the instruments that we created. Now comes the more interesting part, is the wearables. We've all heard of augmented reality, mixed reality. I'll just give you a small brief about all three realities. The virtual reality is wherein you wear goggles, but then you are blinded to the real world. You're just watching a theater-like experience in 360 degrees. Augmented reality is when you're visualizing the world, but at the same time, there is some information coming in onto your eye telling you that, okay, that's the senior judge, Manmohan Singh, sitting there on the bench, on the first row. Even if I have not been able to recognize him, the software would feed that to me. That's augmented reality. And then comes mixed reality, wherein you're able to mix both the worlds, the virtual and the real. At present, what we are doing is we are taking this 3D bone models that we created and on which we planned into the OT, and then matching them onto the knee so that we are able to visualize directly on the patient all that what we had planned and then execute it like a human robot. So lots of interesting things happening. At the same time, lots of AI also going in. How? Because we have a huge data set and we've started learning our computers onto that data set so that they can actually recognize the bone, they can recognize the parts of the bone and fit them on. The newer thing is that we take CT scans of patients before and after and see what have been the satisfaction scores of surgery. Based on that, we run the algorithms to see what are the kind of factors which will make a difference in the outcome, and try and come up with newer factors which will make the difference to bring it to 100%. So lots of exciting things happening here. A small this thing which we feel is lacking on the Indian side is that unlike the US, we do not have laws which prevent our data from going offshore. As data becomes increasingly digital, Indian data is a gold mine. Allowing it to leave our shores is going to be, or possibly, a huge loss of revenue in future. And probably the legal community should do something about that for the future.
Thank you so much for throwing light on two things. One, how AI generated technology is helping the healthcare sector, and two, how you have conveyed a word of caution that there should be something which should be done as far as the legal front is concerned. With that, I'll go to Ms. Lakshika Joshi, and I'll with her expertise and experience in the context of semiconductor manufacturing, how does the global nature of the industry impact intellectual property rights, and what challenges arise in enforcing and protecting these rights across international borders?
That looks like topic for a book. But anyways, I'll try to be precise. And before I start, thank you again very much, YJ Trivedi and AMA, for having me here. I learned a lot from the previous panel and, of course, from what Dr. Sab just mentioned. In fact, as he was speaking, there were multiple thoughts that were going through my mind, and there are so many use cases in the medical side. In fact, one of my cousins, she's a professor at King George Medical College, and she had called me a couple of months back. What she wanted to discuss was, she's a professor, she teaches medical students, and she teaches anatomy. So she was telling me that she has created a few models. Those are extremely innovative, and she wanted to discuss if there's a way she could patent them and how should she protect them, because, and she had no knowledge of what IPR is, she had no knowledge of what patents is, she had no knowledge of if any protection is available. How she became aware was because her models became so compelling, and they were so good for teaching methods, that a body in the United States approached her, and this body is actually a syndicate that takes permissions and then licenses it to many other medical and other learning institutes in the United States. When they approached her to seek her rights and asked her if these are patented, how much she will charge for licensing these, and when she got that kind of a mail with a contract, she could only think of me and thought she should get in touch with me to ask what it is. So what I'm saying is, I'm so happy to hear what Dr. Shah just mentioned, because as a doctor, as a professor, she's teaching so many doctors in the medical college, but even she was not aware of something called intellectual property rights. She comes from a family of doctors. She's a third generation doctor, but they're not aware of. And she's doing stuff which is innovative, which calls for protection, which somebody outside India realized and approached her to get licenses to that. And her own college, or it's a government college, KGMC, they did not realize, they didn't think that it was worth enough, the protection. Anyways, those were the thoughts that were going through my mind. So there is a lot of innovation that we have in this country, which is just getting lost because people do not understand, or they have no knowledge of how to protect. And what should they do to protect? Where should they go to protect? So, for example, she did not know that there is an initiative, there is an innovation cell. And when she even tried to approach that cell within the medical center, that cell is almost non-functional. No doctor or no professor ever teaching in the medical college had ever filed a patent. So, the efficacy of that cell is actually almost zero. Although there is an initiative from the government, anyways, that's a different story. So, but you asked me about the industry side. Similarly, on the industry side, this is happening all over. The industry, thankfully, realizes the importance of protection, realizes the importance of leveraging technology for more use cases, because that equates to revenue for them. And anything that equates revenue is what becomes important for industry. So there are a lot of new technologies that we deal with, whether it is the metaverse, the earlier panel talked of metaverse, and I was thinking of a very interesting use case. We have a metaverse lab at our company, and we are developing a lot of use cases to use metaverse not for entertainment, but for heavy industry. For things, just to give an example, there are some very difficult mining sites where it is difficult to approach the site, and humans cannot go to correct machinery there. You can simulate that environment. You can use metaverse to actually see how that happens. Then there are also sites of in the military defense use, when there are advanced deployments, actual human testing may not be possible in those areas. And that's when you use these new age technologies to actually experiment there. So there is a lot of use case. But having said that, as lawyers, we always love to create problems because that is revenue for us. So anyways, with all these good use cases and how we can leverage technology to get money as lawyers, when we wear that hat, we advise customers, clients, and also our own companies on the other side of it, which is the risk and the exposure, because that's our job. And there is a lot actually there, because it's a developing domain. So just to give you an example, the whole, as Dr. Shah also mentioned, the whole play is built on the fact that these technologies are going to scrap a lot of available data. Whether, for example, they will scrap the internet for creating a data set or creating your AI models. Similarly, they will scrap a lot of data from existing public domains. And there's a huge debate that is ongoing right now. Of course, in India, we are not debating that yet. But in the US and elsewhere, and primarily in the US, because we've since 2020, we've had multiple cases being filed where people are actually questioning if it was a copyright infringement, if my book or my poem or my data, which was available freely on the internet, was used to train an AI model. Because just to take you a step back, anything that you generate, you have a copyright over it, you have exclusive rights to that. Having copyright means you have exclusive rights to a particular piece of content, which means that anyone who needs to use it or refer to it, except of course if it is for fair use purposes, which are defined even under the US Act, if it is internal use, reference purposes, and so on, you cannot use someone else's copyrighted content and create a business model on it. But if you look at how AI systems are built, AI systems use a lot of machine learning where they scrap the data, which is freely available, publicly available, but that data is also copyright protected. So there's a whole debate which is going on whether scrapping to someone's copyrighted content or someone's intellectual property rights protected content only for the purpose of training your data models, which will then be used to create some AI simulations or some other use cases. Is it a fair use or not? And this is sort of still under debate. So I don't have answers, but I surely have a lot of questions, which I can ping you with. But I really don't have answers to it. However, in some cases, in a very specific case, and as lawyers, we have a very favorite disclaimer. We say everything depends on, quote, facts and circumstances of the case. So even if I were to give you, let's say, one case or another judgment, everything ultimately boils down to facts and circumstances of the matter, and that's really nice because, that's a very classic universal disclaimer, gets you out of everything. So coming back to what I was saying is, there have been cases. There's been a very famous Andy Warhol case that started in the United States District Court. where, for some of you who are not familiar, Andy Warhol was a portrait maker or a painter, and his style of painting was that he will pick up real life objects. For example, a can of Coke or a tin of peanuts from, let's say, Haldiram. He will pick that up and he will paint that. So there was a whole debate in let's say 50 years back whether that he's picking up that can of Coke and creating and painting that, is that a new work? So because it's sort of taking away the trademark, taking away a lot from that can. But then in that era, it was held that it is all fair use, because what he's doing is a transformative use of the same thing, and it's qualified as fair use. The debate actually became, so it was a settled thing. But now, in 2020, what happened was there was a photographer called Lynn who had taken some pictures of, I don't know if you're familiar, there was a singer called Prince. And she had taken pictures of Prince, and when Prince passed away, Andy Warhol is no more, by the way. All his rights, everything is run by Andy Warhol Foundation. Andy Warhol Foundation actually took photographs of this photographer, which was obviously copyright protected, and created portraits based on that. So you take the picture and you create an exact same portrait. You're not copying it, but you're actually seeing it and creating that. And put it out and started charging money for it. The district court in the US said that it is okay because it is fair use. That was a photograph. But this is a transformative use. It's allowed. It's fair use. It went to the Court of Appeals. Court of Appeals reversed the judgment and said, no, it's not fair use because it's pretty much the same thing. You know, that's a photograph and you're creating a portrait which is exactly the same, except that it has some orange tone in the portrait and the picture was black and white or something like that. But then it went to appeal to the US Supreme Court, and there it was settled that what Andy Warhol Foundation did will not qualify for fair use. So what I'm saying is that if that does not qualify for fair use, means taking someone's content and creating your own content based on that, then how is it that when we are using a lot of content which is available, whether over the internet and other public places, and using it to train data models for AI purposes, for my AI tools, is that valid? Is that not infringement of copyrights? And there have been other types of cases also. A lot of people have filed class action suits in the US where they're saying that usually engineers, when they code, when they create any software or they build any software, they use a lot of open source software. Now, open source software is software which is available out there for anyone to pick up and use and modify, subject to certain terms and conditions. So a lot of open source software contributors have filed class action suits saying that, I don't know if you've heard of Microsoft, AWS Code Whisperer, Microsoft GitHub Copilot. These are some new age coding platforms that, how should I explain this? Have you heard of ChatGPT? I'm sure all have heard. So the Copilot, Microsoft Copilot is ChatGPT of coding world. Once you start coding an algorithm, it will give you a prompt and the rest of the code it will finish on its own. Same is AWS from Amazon. So it's like the coding of ChatGPT. Then you also have many other platforms which are the ChatGPTs in image world, ChatGPTs in a video world. So there are tools available where you put text and based on your text, it will create photographs. There's been a very interesting US case law on that also, because one of the artists, she fed in a lot of text, just textual items, and based on her text, portraits and cartoons were created and a full book was published, and this book was also granted copyrights. So then the whole question arose whether AI generated work can be protected, because this work is not the work of an artist. This work was developed from a tool. A tool generated this, just like Dr. Shah mentioned. Tool is simulating and creating certain bone structures and 3D images. Now, can I copyright those or not? That's also a very big question. Can I protect the AI generated content, whether it is on the copyright side, or if AI creates something innovative, can I patent that? So across the globe, at least as of now, the answer is no, you cannot patent it. On copyrights, the situation is slightly mixed. I don't know if some of you are aware that in 2020, our own Indian Copyright Office granted a copyright to an AI who was the co-author of a painting called Suryast. It's again very interesting situation where this person filed 2 applications. One application, it filed only the AI as the author of the work. That was rejected. Another application was filed where a human and AI was copyright owner, and that was granted. But again, so what I'm saying is, with these new age technologies overlapping with IP laws, there are more questions than there are answers right now.
Sure.
And it's becoming more and more complicated as
So
we go
the question that you have posed is definitely most contemporary, and I think the entire world is trying to find an answer. And the confusion probably lies in the fact that the law recognizes entity that can be given personhood. So how do you grant personhood to machine? And then who will be liable? And that's a long story. So thank you for posing that question to us. That gives me an opportunity to go to our third distinguished speaker, and a very interesting name that you have given to your startup, which is Ishitwa, right? So something on that, if you can share. And then if you can throw some light on the IP aspects that is covered in creating your AI-based, the solution that you have given for automated waste sorting solution that you have named. So just on that.
Okay, so name Ishitwa. If you visit our website, you'll find many names originating from our mythology, Sanskrit. Ishitwa is actually a name of Bhagwan Hanuman, which depicts the supernatural power. And that is what we're trying to do in the area of waste management when we are deploying AI to solve a very big problem. So what is this problem? I'll just highlight before when you come to the question you asked. I don't know you guys are aware or not, but less than 10% of our plastic waste is recycled in the world. Balance is going in the landfill, getting burned, leaching into water bodies. Very small portion actually reaching till the ocean, and that itself is so huge that by 2050, total weight of plastic in ocean will be more than total weight of fish or life in ocean. This is the biggest problem humanity has created for itself. And you know why it is happening? It is happening because humanity generates waste in mixed form. In order to really reuse and recycle, we need to segregate the waste. Imagine, our cities, Ahmedabad, for example, generates 4,000 tons of waste in a day. How to segregate this waste? You will find human labor deployed to segregate this waste. Other than being dirty, dull, and dangerous job for a human, even in COVID, I have seen biomedical waste being segregated by hand. It is not a job for human, and when they segregate it, also the efficiency is very low. You need almost 15 to 20 human labor to segregate 1 ton of waste in full day. The developable technologies which have built on the basis of reflection principle, that you throw light on any surface based on what is the surface, certain bit of light is absorbed, certain bit of light is reflected. You can identify the polymer and then you can separate mechanically. This is a beautiful technology for commodities like food industry, mining industry. But waste industry, it was a struggle, because waste often will have a layer of dirt on surface, reading will go wrong, black will absorb light. These objects will have certain portion covered with stickers or sleeves. Entire packaging, food packaging is multi-layered. Any reflection sensor can read top layer. So there are many challenges with this. So what our team did, we were working on figuring out how to solve this. So we wanted to create something which is achieving the good quality of sorting like human does, but very inefficient way. So what we have done in last 7.5 years, we have built a neural image database of the objects. All the waste which we throw in our dustbin, we have created a neural image database. And at a very high speed, our AI vision, our machine vision can identify the object. What is the polymer? What is the color? At a 3.2 meter per second speed, we identify the brand. So with that level of identification, with that level of power of AI, we are able to segregate the waste. Our one machine, which we have created, can segregate almost 6 to 7 tons per hour. This is the technology which is completely going to transform how our waste is being handled and managed by the world. There's a lot of innovation here. One is machine vision, and one is the hardware itself, the robotic arms or the pneumatic system, how they interact with each other and how they're performing the task which we are supposed to perform. So there was combination of aspect here involved, and that is why for me it was getting a patent for it, for these kind of innovation was not really difficult. Guilty in charge, Nidhi, I am out of CXOs in this field, or CXOs in India, I'm well versed with IP. I was one of the first founding 15 team member of company named Pangea 3, which was, we coined the term LPO, legal process outsourcing, to the world. So I was doing IP consulting for Fortune 500 companies, Apple, Samsung, all those companies. I used to advise them how to protect technology. Gaining from that expertise, I knew that how to protect our boundaries, how to protect our technology. So since beginning, we're very clear that at what stage we need to file patent, what stage we need to extend it to WIPO, what stage we need to extend it to different jurisdiction, because patent is a jurisdiction-specific task. But for us, it is easy because innovation was with hardware as well as with the software. It is a very complicated task for robotic industry right now, because in India, software is not a patentable subject. Business methods and software is not patentable. You'll have to have a combination of hardware, how hardware is interacting with the software, and that is a very tricky situation. And there is a gap in understanding in the industry. Many early stage ventures don't understand. They just know that software is not patentable. They don't attempt to patent. There are many innovations happening which they are not getting, the right due or right credit for what they have created. And patenting is not a selfish act. It's not only protection. It's also dissemination of information. The original thought process why patenting, concept has introduced that so that people tell the world that this is what the innovation is. So it is required that a right kind of knowledge base is created for the early stage venture startups, so that they understand that yes, software can be patented if the hardware combinations can be explained in that way.
Sure.
So,
thank you so much. Yeah.
To that, for benefit of everyone, that software is also patentable now. We've had some very good judgments from the Delhi High Court, Ferrer Delani, which has given a boost to how just software also can qualify for patents. It's you're right. Earlier, the perception was that it's only coupled with hardware that you would get patents, but that's changing very fast. In the last 2 years, that's changed quite a bit, especially after the Delhi High Court judgment. There's been a huge boost in filings, I would say.
From my own experience with the perseverance of Gopi, we'd almost given up hope on the software patent. But then after a struggle of 4 or 5 years, we have a pure software patent. Thank you.
So I'll just build on it a bit more. I think what Lakshika was talking about, when we understand AI, everybody is right now talking about ANI, which is a narrow AI, artificial narrow intelligence, where AI is used to do a narrow task or a specific task, which it is doing better than the human. It is right now can be defined who is the inventor, because human is end of the day doing the prompt, human is end of the day giving the input. But the direction where the technology is moving, now AGI is not very far, and maybe ASI is not very far, which is artificial superintelligence. When it will start inventing itself.
then where will the ownership right go? Where will the IP right go? That is the main conflict which is coming up very soon in our life.
Although, on a very different note, I'm told on the semiconductor side, we still need those kind of processing chips to process. Yes. So another 10 years, who knows?
I think I would have loved to come to you for another round of question, but knowing AMA and its punctuality, I have already received the message, but I will just try to conclude. I think there are 3-4 things which have been highlighted. I think number one, the debate definitely is on artificial intelligence and IPR, how to grant ownership rights for in case of AI generated work. And that is, there, in fact, the trademark is also being impacted with AI. Earlier it was only patent, then people realized the copyright is also there, the design has also joined that group, and now of course the remaining type of IP is also part of it, because we cannot avoid AI generated work anymore. The second important thing which is highlighted is that what we never used to protect, especially business methods and softwares, but as we have known that it certainly can be, and I'm sure soon there will be a legislative intervention which will certainly help, because it's very difficult not to grant patent that way to software, because that will otherwise hamper us probably adversely compared to, because if we are comparing with US, though they according to their constitution, anything under the sun is patentable, which is not the case as far as Indian system is concerned. We are more stringent, they are more liberal.
And everything is also fair use according to their system.
Yes. So, but our fair use standards are also very different, which was highlighted by her. And that is another important thing. I think one thing which is highlighted by Sandeep is something which is, if you are little bit aware about IP, that probably can take you a long way. So he was quite comfortable coming out with this technology because he knew how to protect it, as he has this kind of experience to back him. Not necessarily I'm saying that all those who are working in different domain should learn about it, but I think some basic and fundamental knowledge if is there, which is sort of, you can say, at a level of basic awareness. I think that can also take a particular that can definitely help you at least identify who can help you the best, right? I'm sure, and I will never advise that. Yes, because I am a lawyer first and I prepare lawyers, right? So I would never advise that. But the basic level of awareness will certainly help you identify who can help you the best in a given situation. So I think we all need to get involved in a very conscious and constant discussion on how IP can play a pivotal role when the technology is developing at such a fast pace. And the difficulty is, as I mentioned, law is a reaction, not an action. Technology is an action, the actions are multiple, and the pace is such that law is unable to match with. So that's how we feel that there are certain gray areas and debatable points. But I think that debate is required, and that is the reason we are all together here. Under the aegis of IP Summit, we are here and discussing how IP can play a role in different industries, and also how IP can meet with the demands of emerging technologies. So I think these kind of discussions certainly will add a lot of clarity to where we need to move forward in future as far as the global race of innovation is concerned. So something that somebody want to add? Yeah, thank you so much. And we had a wonderful discussion, I hope. Due to paucity of time, I'm not opening the floor for questions from the audience. Thank you. Questions?
So I think the question and answers would be handled at the dinner session. So thank you, Nidhi, for having the wonderful session. You did a great job as a moderator. Now I'm here as giving the vote of thanks for the entire program. So on behalf of organizing committee and executive committee at Ahmedabad Management Association, first of all, I extend my sincere thanks to one and all present here. My deepest gratitude for our chief guest, Mr. Manmohan Singh, who traveled all the way from Delhi from his busy schedule. So we really appreciate your presence here, sir, and your words of wisdom, sir. The first panel, which talked about IP generation and monetization strategies, Mr. Satyadeep shared his experiences in in monetizing the copyrights with regional context, then to national and then to international scenario, and how they all are, inter-relevant. So that was really meaningful. And Ms. Bindi articulated her company's strategic approach as how she was vigilant about protecting IP rights before launching the products, which is buzzing in the town right now. She was also assisted by her husband, Mr. Urvish. Thank you so much for your insights too. Then came Mr. Nishit, a prominent lawyer in the field of sports domain. And we really went on to the sporting event. We were virtually there and we could feel the buzz there. So he really showed how important it is to pick up the infringement in such a short span of 12 seconds and encash on that and monetize in that particular way, and many more in that particular aspect. Mr. Anubhav Kapoor, who very adeptly guided the panel discussion. Thank you so much. Then came the second panel, which delved into the implication of emerging technologies. We had three brilliant panelists. We'll start with Dr. Manisha, who himself found that there is no ready solution, so why not to find one? And then he took help of the emerging technology to solve it as a pre-operative solution. And look how healthcare can be benefited with such emerging technologies. And I think his urge is still on. He's into the inventing mode, and he might come up with new solutions too. Ms. Lakshika Joshi shed light on her experience with her technology-based portfolios, and interestingly, she posed more questions than the answers, and I think the audience is right now in the thinking mode that how to deal with them all. And Mr. Sandeep very rightly pointed out on how pre-filing of certain IPs help in preserving the entire business portfolio, no matter what the industry it can be. And this time it was getting the cleaner environment through robotics, through emerging technologies, and through IP. And that was really, really brainstorming. In and all, there were invaluable insights, experiences, current trends, futuristic approach, all together really led this as a very, very successful event. Thanks to all the stakeholders, they did their best. Thanks Nidhi, not to forget, she did a brilliant job on navigating the entire panel discussion. And then how can I forget my delegates and attendees? All the attendees, they made sure they are physically present here, not scrolling through their mobiles, and they were really, really into the sessions. Thank you so much for your attention. And I'm sure this has been a very learning experience for you all. I share my heartfelt gratitude to the dedicated staff at AMA and the volunteers, namely Parth, Darshi, and Dhruv, who did their job, and they are really not unnoticed. If I forget any of the volunteers, please pardon me. It goes to each and everyone who did their job. And I also extend my sincere appreciation to Team YG Trivedi and Company for their continuous and sincere assistance in executing this summit. As we conclude this IP summit, let us carry forward these insights which we have gained today, and let us make an effort for the advancement of this intellectual property regime altogether and contribute to the growth of this segment. Thank you once again to each and everyone present here. And two announcements. Please enjoy the dinner which is ready at the ground floor, and the panelists are also there, so you can, scratch their heads, right? And for the students, there is an announcement that please collect your certificates of attendance from the office. They are outside only, so you can take her help and she will guide you through. So thank you once again and have a great evening ahead.